Is there anything that you have questions about before we get going?
No. Is there an introduction, or I can introduce myself and the topic and just jump right in?
Yeah, that would be great if you just want to introduce yourself
Perfect.
and jump in. I noticed that you had a little slide about your credentials and whatnot, so if you can, you know more about you than I do, so I'll let you take care of it.
I can definitely appreciate that. All right, I think I'm good to go.
All right, I'm hopping off the mic now.
All right, thank you. Well, hello everyone. This is Paige Duggins-Clay from Husch Blackwell, and I'm delighted to be talking with you today about pretty much my favorite topic, restorative justice as a response to campus misconduct, and really all kinds of misconduct and bias incidents. I'm delighted that Jana's campaign and the Rocky Mountain Campus Safety Summit is having us on, and let's dive right into this really important and timely topic. Before we get started, I always think it's helpful to give a little bit of introduction so you know who's talking to you, since we're doing this webinar format today. Again, I'm Paige. I work at a great law firm called Husch Blackwell. My firm is a national law firm. We have offices all over the country, but I'm fortunate to be based right here in Austin, Texas. I'm a graduate of the University of Texas School of Law, and perhaps even more importantly, I have a degree from Southwestern University in Education and Race and Ethnic Studies. I thought for a long time I was going to be a secondary teacher and soccer coach, but after I had some really great administrators and professors and all sorts of support folks at Southwestern, I really got steered towards pursuing law and advocacy, and I really feel fortunate that I now have the opportunity to give back to my clients who are almost exclusively higher education and K-12 institutions of education. After I graduated from UT Law, I spent a year clerking for the Honorable Justice Jeff Boyd on the Texas Supreme Court. It was an invaluable experience and taught me a lot about the law and a lot of other really important issues. And I'm grateful for that experience and that I'm able to bolster my experience and share that with you today. Let's dive into this topic. Here's some things that we're going to cover. We're going to talk about what restorative justice is and how we can incorporate it into our informal resolution processes and also our community building processes. One of the really interesting things that I'm hearing, especially in the wake of some of the national politics and incidents that are happening across our country, is that there's a really deep, almost universal dissatisfaction with our traditional investigative and adjudicative models for dealing with student misconduct and dealing with larger bias incidents. The question that we're really focused on here is there an alternative to these investigative formal processes, which are still really, really rigorous, but also are more in line with our educational values that we have as colleges and university administrators. We're going to talk about what the process of restorative justice looks like as a response to campus misconduct and walk through some of the mechanics of that process. And we're going to focus on how restorative justice differs from mediation and other informal resolution processes that have historically been criticized by survivor advocacy groups and other groups. Finally, and most importantly, I'm a lawyer. I'm going to give you some law, and we're going to talk about what our legal obligations are when we're implementing an RJ informal resolution framework for Title IX cases and for all sorts of other cases. Let's jump right in. Everyone always asks, what is restorative justice? And I think what's super interesting is there seems to be a resurgence of interest in this topic in the recent year, largely as a response to political, social activities that are putting institutions of higher education right at the forefront. My other observation is that there's also seems to be a lot of confusion about what restorative justice actually is and how we can implement it. So I'm hoping to do some myth busting here. As you can see here, we've got a slide that offers just that soundbite quote. This is Howard Zehr, who's widely credited as one of the leaders of the restorative justice movement in the United States. His work is largely focused on the criminal justice context, where he created a series of victim-offender dialogues for individuals incarcerated for various offenses to meet and mediate with their victims in order to bring restorative justice. And Howard Zehr defines it this way. Restorative justice is an approach to achieving justice that involves, to the extent possible, those who have a stake in a specific offense or harm to collectively identify and address harm, needs, and obligations in order to heal and put things as right as possible. That's a soundbite. let's talk a little bit about what that means and unpack it. As we'll discuss later, a central aspect of restorative justice is storytelling because it helps us better understand ourselves, individuals impacted by our actions, and our community. That's why I like to start these presentations off by telling a story of my own. So here it goes. In 2015, as a second-year law student, I joined a pro bono project focused on eradicating the school-to-prison pipeline. At the time, Austin, like many large urban school districts, was under fire from the community due to the publication of a report highlighting the extreme disparities in exclusionary discipline, by that I mean suspensions, expulsions, and alternative education placements, on two key populations: racial minorities, particularly Black male students, and students with disabilities. As part of that project, I helped organize community members to share their experiences with the Board of Trustees. I also drafted revisions to the district's Student Code of Conduct that made two key policy changes. One, it banned the use of discretionary, i.e. nonviolent and non-drug-related suspensions for elementary-age children. And two, importantly for this story, it adopted language for students of all ages centered on social-emotional learning, including a requirement for schools to consider alternatives to traditional exclusionary and punitive disciplinary actions, including restorative justice. Fast forward just a few years. A 12-year-old sixth grader, was called Sam, was in the gym during a PE class. During one of the activities, he noticed he was feeling weird and uncomfortable and realized that, for the first time, he had an erection. Embarrassed and not sure what to do, he looked around in a panic. A young woman sitting near him noticed his odd expression and came over to ask him what was wrong. Without missing a beat, Sam blurted out, "Can't you see I have an erection?" The young woman, understandably shocked and disturbed, immediately told the PE coach what Sam had said, and the PE coach immediately sent Sam to the principal's office. Sam was immediately suspended, pending an investigation. I came to visit Sam that same day, where we talked about what had happened. I immediately raised hell because it turns out that Sam had an IEP for being on the spectrum and a history of anxiety issues that required the school to engage in the least restrictive disciplinary measures. I also reminded the school about the district's new policy language requiring them to consider alternative disciplinary practices and encouraged them to try restorative justice. They agreed. So what happened? Sam met with the counselor, where he explained how embarrassed and confused he was with these new feelings and bodily activities. He said he felt ashamed and mad at himself for what happened and mortified that he had made his female classmate uncomfortable. He also was extremely terrified to go back to classes because he knew all his classmates would tease him, or worse yet, they wouldn't talk to him at all. The counselor worked with Sam to process these feelings. She provided a book for him and his parents to read to talk about the changes happening to his body. She reassured Sam that what he was experiencing was natural and normal. She also met with the young woman, who said that she was disgusted and thought that Sam was trying to harass her. She shared that this is a common aspect of what was happening in middle schools, and that boys often made comments like this and laughed at young girls. As part of the restorative process, Sam and the young woman exchanged a series of letters where Sam explained that what he was thinking and feeling at the time and apologized. His letter included the steps he was taking to handle these situations better in the future, and he promised to stop his friends and other boys when he saw them harassing or making fun of girls. Finally, the counselor organized a series of lunch groups for Sam with students from his various classes to help them reintegrate back in. By having these events, the counselor showed both Sam and his classmates that the process they engaged in was not punitive, but it was meant as a learning experience and something that everyone should be proud of. Now, I know that was an example from the K-12 context, but I'm hoping that you can see some of the really important themes that will translate across all sorts of sectors, including higher education. A key defining factor of restorative justice is that it's focused on repairing harm. Notice that nowhere in that story I just told did I actually mention the word code of conduct. After the restorative justice process got initiated, the focus of the process became on what was the harm committed and how we can make it right. In our traditional conduct processes, we ask, what rule was violated? Is there enough evidence to support a finding of responsibility? If so, how do we punish the offender? And did we follow our policy to avoid liability? Apply that sort of framework to what happened with Sam. Is that the sort of conduct that would have met the definition of sexual harassment under Title IX, or alternatively under our student conduct process? What would an investigation have looked like? Would it have been productive? Have we found no policy violation? Would anyone have been satisfied with the result? Probably not. The restorative justice process, as I showed you in that example, asks different questions. What's the harm? Who's responsible? What can they do to repair that harm? And how can we rebuild trust? And we'll walk through, again, how that process unfolds, but I hope that the story I told highlights some of those key principles. Another defining characteristic of restorative justice, as opposed to our traditional conduct processes, is that restorative justice empowers the key stakeholders. I like to just pause here and ask you to reflect and think about our traditional processes and think in your head of these courtroom procedures. Now, I know we've got, the new Title IX regulations, and they've been criticized as increasingly pushing institutions of higher education to operate like quasi-judicial bodies with full-blown live hearings, cross-examination, advocates and attorneys involved. Let's compare that to what restorative justice looks like. The harmed parties, including the school, are central to the process. They're not bystanders sitting at the witness table or in the audience. They're front and center. The participants are speaking with themselves, with an advocate or a support person. And instead of there being a judge or a jury, there's a trained facilitator who mediates the conflict and goes back and forth and is impartial. Finally, and most critically, the person who causes the harm must take responsibility and must be an active participant in the process. They can't just sit back and be sanctioned and judged. They can't just plead the fifth and this one out. They have to be an active participant in making things right. Finally, restorative justice is an ethical and an educational framework. As I alluded to right at the very beginning of my story, this process grew out of a community-based effort and resulted in policy changes looking at systemic issues affecting the community and the school as a member of that community. My good friend David Karp, who is the director of the Center for Restorative Justice at San Diego, has this great quote: "The way we respond to student misconduct symbolizes the kind of community we aspire to be. Restorative justice offers a different approach that's educational for the student, that also meets the needs of the hard parties and the institution." What we've got here to the right is a model for how we can understand how restorative justice fits into the spectrum of our conduct responses. Restorative justice assumes, as I hope you all do, that our students are moral actors, that they're good people, and that our goal as an institution is to not only educate, but to educate for a career or profession, but to educate for humanity and for community. This is different than our traditional conduct processes, which often rely on things like deterrent and incapacitation, progressively removing students who don't abide by our standards from the community. But restorative justice asks for apologies, restitution, community service in order to build trust and maintain standing in the community. Fines are often a deterrent principle that we use and assume that you have a rational actor. Finally, when we're removing students, what we're saying is you are an immoral and an irrational person. You're not worthy of our community, and you're not capable of rehabilitation. And while there are certainly circumstances where that's appropriate, we'll talk about the situations where restorative justice is not appropriate as a response to misconduct a little bit later. I'd like to think that all of you all with your selective institutions and admissions requirements, that you really believe in your students and that we're capable as educational institutions of doing more. Let's talk about why we should use restorative justice. And I've given you some kind of big picture philosophical reasons, but we'll talk about some really practical reasons now. Before I jump in, I like to use this moment to just pause and say, right from the beginning, I started with a quote from Howard Zare, but I want to acknowledge that the principles of restorative justice have long and well-settled traditions in both Indigenous and African groups. And there's a rich history that there's not enough time to delve into here, but I really encourage you to explore it because there's some really great thinkers and actors who've been writing about this for a very long time. Now you might be asking, why on earth would a person who's who's been harmed participate in this process. The reality, and I think everyone can appreciate under the new Title IX regime, is that traditional investigative and adjudicative processes can be incompatible with the needs of harmed parties. You've got long and intrusive investigation and decision processes that often involve personal questions and examining. You've got the potential for re-traumatization in a variety of forms, both in the reporting and the initial investigation, now in a live hearing and cross-examination, and then potentially in an appeal, and then potentially in litigation. This is a process that doesn't necessarily create the most conducive environment for coming forward and participating and getting your needs met by the institution. As I just alluded to, we've now under this new regime, and if you're in the Sixth Circuit, you've been dealing with it for a while, the confrontation and cross-examination requirements, a huge deterrent, as many advocacy groups have pointed out. I think the other piece that people often overlook when they're talking about alternatives to traditional investigative processes is that often the people who are harmed actually have a deep concern for exposing the person who harmed them to disciplinary sanction. We all know that and the research is well settled, that the people who often cause harm, including sexual harm, are often people, or most often people in our communities, people we know, people we have relationships with. They might be our friends, or boyfriends or girlfriends, people we trust. It's that sort of reluctance in creating a space where even those sorts of situations can be resolved that restorative justice is particularly good at. Finally, and relatedly, there's concerns about confidentiality. This is a really deeply disturbing and in some cases traumatic incidents that happen, and you don't really want an investigation that's going to drag all your friends into it, create rumors and hubbub, and again, subject the person you might care about to some sort of severe sanction. And this is just an illustration of what that looks like. Been doing restorative justice for a while now, and these are some of the things that I've heard people say when they participate, when they're a harmed party participating in the restorative justice process. I want to stand what happened. I want to hear you say that you're sorry. I have questions that only you can answer that a traditional investigative process isn't concerned with. I want to know that you're not going to do this again, but I want to know that something good can come from this and not just more harm. Addressing these social emotional issues is critical to institutions of higher education and all educational institutions, and it's why restorative justice might be a good and better fit for a response to all sorts of student misconduct. It's another reason that we maybe need to consider more options. This is some research done in a slide put together by, my friend David Karp at the University of San Diego. A survey done in 2017 at Midwest University showed that out of 834 students, 34%, 284 women, were sexually assaulted. Of those 284 people, only 16 of them actually reported it. And of those 16, only 5 or 2% actually filed formal complaints. So let's back up. That means that the vast majority of the people impacted by, in this case, sexual misconduct, were not even reporting to the institution and therefore not having their needs met. For all the reasons that we just laid out, we've got to create more options so that we can get those students coming forward, meet their needs, and find ways to help them move forward in an educational, supportive, restorative way. Now you're probably thinking, well, gosh, why would an individual who causes harm participate? And this is a really interesting question that we get a lot. Let's talk about some of the reasons why. This is another quote from Howard Thayer, where he explains, accountability involves facing up to what one has done. It means encouraging offenders to understand the impact of the behavior and the harms they've done, and urging them to take steps to put things right as much as possible. Well, this is a great principle. The huge problem with this is that students in particular are not going to be motivated to come forward and participate in this process if they feel they're going to be subject to even more rigorous processes, and that might be exposing themselves to admissions that are going to have serious disciplinary consequences. Now, let's be really, really clear. What we're not saying is we're not going to have students be accountable and that we're not going to take misconduct of all sorts seriously. Instead, what we're saying is the way that we're going to respond to this harm is we're going to make it non-adversarial. We're going to create a space for this person who's caused the harm to accept responsibility and to have an opportunity to hear from the persons who've actually been impacted about the impact of the harm they caused. Consistent with our mission as an educational institution, we're going to give that student an opportunity for education and growth. And we're going to meet the needs of that student by helping them regain their social status and their reputation. Again, for most of our students, we believe in their ability to reconcile themselves and to come back to our community. Restorative justice provides a model for students to do that. Here's a great example, and if you haven't had a chance, you should really check out this podcast. It's called The Reckonings podcast. In episode 21, it's this great story about some pseudonyms, Anwen and Samir. And it's a Title IX case, and it's worth a listen, particularly in the current climate. But I was listening to this a while back, and this is a quote that I really felt resonated with why exactly it is that respondents in all sorts of matters might want to participate. This was Samir, who said, "I was terrified that I assaulted her. I was terrified that I'd hurt her in this way. I was terrified of myself. Because if this was true and I did assault her, then what did that make me? I was terrified of being found out. I was terrified of being sent to jail. I was terrified of all the consequences that come with sexual assault and rape. And I didn't have anybody that I could tell because, like, how do you say, hi, I think I assaulted and raped somebody, but I'm not entirely sure." Does this sound a little familiar? Think about Sam in my hypothetical earlier. He was willing to admit that he had made a mistake, that he had hurt, and he was mortified and afraid of what was going to happen next. Restorative justice is perfect for these sorts of scenarios, where you have a person who's willing to acknowledge and admit responsibility and just wants to find a path forward. It's also worth noting that in this case, the complainant, Anwen, delayed reporting her assault for almost a year and a half because she was so worried about the exposure and the scrutiny. Samir was a person who she liked and respected. He was a fellow RA. He had a great standing in the community. He was very influential. And she was worried about tearing that down, but she ended up struggling with that and almost ended up dropping out of school. Restorative justice offered both of these individuals an opportunity to mitigate that and to have an honest conversation about what happened. We'll talk a little bit later about the restorative process that was employed in this case, but suffice it to say it was a positive outcome, at least for now. Finally, we have to mention the other big stakeholder, the institution. Why would you guys want to reinvent the wheel and try something different? As we've already highlighted, restorative justice serves the institutional goals of promoting safety and furthering our educational objectives. Again, we want to create more opportunities for students to come forward so we can meet those students' needs and figure out what's going on in our community in cases where things are not already being reported. It's also potentially a more effective use of resources, and we'll explore that on the next slide. Especially given the new Title IX regime, we're now looking at even more costly investigations and adjudications, multiple parties and attorneys involved. Can we have an alternative for certain cases that will help reduce that and be more effective? And finally, restorative justice has the potential to increase our satisfaction with our process. If everyone's participating voluntarily and working through and getting meaningful outcomes from this process, is it possible that we'll have less OCR and litigation risk because students won't be complaining or suing as often? Maybe. We'll have to see. Here's what I mean about that, about student satisfaction. This is a survey done, again, by my good friend David Karp at the University of San Diego. They did a survey and they looked at around 550 cases total. Majority of them were traditional disciplinary and hearing board processes, but a small group of them, 165 specifically, were restorative justice processes. Now recall that when students are bringing Title IX claims, especially in the higher ed context, they center around erroneous outcomes. And that means that they felt that the process was flawed, that it was infused with bias. Let's look at some of the key factors that came out of this survey. People who participated in this process, both complainants and respondents, said that they felt that they had a voice in the process. They had an opportunity to take responsibility. They had an opportunity to talk it out. And they thought, most importantly of all, that was fair. Again, there's not good research to support this yet because we're still so new as an industry engaging in this process. But This is a hopeful sign that maybe if we can incorporate more restorative approaches to misconduct, we can reduce our exposure for people being unsatisfied and potentially reduce exposure for compliance and litigation concerns. Here's another good reason to consider restorative justice. This is research again put together by the University of San Diego Center for Restorative Justice, and they researched with a great partner, the College of New Jersey, exactly how much time was spent in the restorative process as compared to a traditional hearing process. And the numbers are frankly shocking. You can see all the time and energy that goes into putting together an investigation and a hearing process, 75 hours total, and the time spent doing a restorative justice process, only 25. You can see that the main indicator here is that you don't have to spend as much time on the hearing and appeal, and there's not as much time communicating via email and other sorts of written notice and documentation because you're doing it in person, building relationships and building a path forward. Now, note, if you have certain sorts of misconduct that we'll talk about later, you might actually have meetings with witnesses because you occasionally involve other community members, and that might add to the time. And of course, the time that you use will vary based on the sort of case and how complicated and how many people are involved. But here's, again, some hope that investing in restorative justice might actually reduce your overall cost. Now with that, let's talk a little bit about what restorative justice looks like as a response to misconduct. As you can see here, a primary method of use of restorative justice is the circle. And lots of people, decry that as a hippie or liberal or crazy, shenanigans. But really, it's a highly effective way of communicating and creating space for people to share their perspectives. The restorative justice process, again, is different because it offers a rigorous, effective alternative to traditional informal resolution and investigative models. Again, we're not talking about some sort of loose informal resolution that's been historically decried by advocates and victims advocates groups. We're still doing all of our compliance obligations. We're providing notice of your rights and options. It's a totally voluntary process that everyone, the offender, the harm party, any support person, are actually prepared for and met with prior to any formal in-person meeting. And all the outcomes that come from a restorative process are memorialized in a final resolution agreement, which we then as an institution monitor and enforce. We don't have enough time to talk about all the ways that we can integrate restorative justice into our campus misconduct responses, but here's a little snapshot of how you could do it. Restorative justice really is a whole campus approach. And while we're focusing today on Tier 2, the restorative conferences, especially given the current events and the current climate, it might be worth considering Tier 1 restorative justice approaches. Let's walk through this. Tier 1 involves building and strengthening community relationships. In higher education, we see these Tier 1 circles most often used in smaller groups such as residential housing, sororities and fraternities, and other student organizations in order to build and strengthen the ties between our community members and establish a shared set of values. For folks looking for ways and methods of facilitating conversations around difficult issues such as racial injustice, systemic injustice, sexual harm, and misconduct, Tier 1 is a good place to start because it creates a space for people to talk safely and it's facilitated. Tier 2 is what we've really been talking about during this webinar, which is an actual response to specific conflict and harm, and that most often takes the form of a restorative conference. Finally, Tier 3 is the re-entry piece, and that's a little bit of what I talked about in the story with Sam, facilitating an opportunity for an affected student or other person who's caused harm back into the community. And those Tier 3 circles are getting more and more important. We'll say just a word about that in just a moment. Now, let's compare the 3 tiers. Here's some questions that you'd ask in Tier 1. Who are we? What are our stories? What are our core values? What kind of community do we want? How will we all contribute to making ourselves to that community? And again, by setting that baseline and creating an opportunity to share those, it creates social ties that will hopefully help deter students from engaging in misconduct, and when misconduct does occur, help everyone having a stake in helping make things right. In a tier 2 circle, again, we ask what happened, who's been impacted, how do we rebuild, how do we address in a restorative way? And in a tier 3 circle, we say, how do we support the person who was harmed and the person who caused the harm as they come back together in the community? Has the person who caused the harm taken responsibility? How do we prevent it from happening again? What sorts of resources do we need for this reintegration to be successful? A commonality between all of the restorative processes and tiers that we just went through is this exact model. The fundamental restorative justice process includes 3 sort of stages. 1, there's a pre-conference stage where we ask and where we do outreach, where a case gets referred to student conduct or to the housing or to whatever entity is receiving the misconduct allegation. We do an assessment of whether or not this is a good candidate for restorative justice. In addition, if we decide that restorative justice is a good opportunity for this case, we do preparation. We don't just put everybody in a room together and start talking about harm. A trained facilitator sits down with each of the involved parties, asks a series of guiding questions, and assesses whether everyone is participating voluntarily and in good faith. Once you've had an opportunity to go through the questions, and those questions will include prep for a harmed party, how are you taking responsibility? What are your ideas for how you come forward? And how are you going to tell your side of the story? And for a person who caused, oh gosh, can I start that section over?
Absolutely.
Okay. Whew. So we've talked about the big picture of what restorative justice can look like, but a commonality amongst all 3 tiers of restorative justice practice involves 3 key steps. First, there's a pre-conference. Again, this isn't just a willy-nilly process where we're dumping people in a room together to talk about their problems. It's a rigorous process where a trained facilitator is doing outreach, assessing whether people are participating in good faith and whether it's a good case for restorative justice, and we'll talk about some factors for assessing that in just a moment, and preparing all the participants. For a person who caused harm, we're asking them questions about, are you prepared to take responsibility? What happened from your perspective? What went wrong? And how can you make it right? For a harmed person, we're asking, what do you want to get out of this process? What are your hopes and expectations? What is your side of the story, and how were you harmed? What do you think needs to happen for things to be right? We're also talking to any potential support persons and witnesses. The person, for example, I've facilitated a restorative conference where a person brought their sister. This is a person who was impacted by sexual misconduct. And the sister was able to share another dimension of how her sister had been impacted, the depression she had felt, the uncertainty, and that added just a deeper layer of what had happened and how the person who caused the harm could take responsibility for making it right and understand what happened. Once everybody is on board and we feel comfortable with the process, we then engage in the conference. And during the conference, there's often a script that you can use, there's a model, you have a facilitator or co-facilitators, and we ask the questions. What happened? What was the harm? How can we rebuild harm, and how can we repair the harm and rebuild trust? The conference is often a several hour long process. We hope to accomplish it in, a couple of hours. I've been involved with conferences that have gone over or have required multiple sessions. But at the end of it, we engage in a brainstorming session of once we have had an opportunity to tell our stories, we then come up with our agreement. We'll talk about the elements of those agreements momentarily. Once we have an agreement for how to move forward, the institution is obligated to monitor the agreement, to mentor the student, to ensure that the student and all parties, including the institution, are complying with the agreement. And again, this is how the Restorative Justice Conference works. We have the pre-conference, the storytelling, all the way down to our agreement monitoring. I'll tell you just a quick story to help illustrate how this process works. As you can see here, we've got a picture of oh gosh. Okay, I'm gonna start this slide over. So that's the big picture of the restorative process. Let's dive into the details of a restorative justice conference, which is what we often use as a direct response to student misconduct. And to do that, I'm going to tell you another story. After a full day of summer classes, two students, we'll call them Hugo and Dennis, were invited to an off-campus barbecue. On their way there, they stopped at a Walmart to pick up supplies and stumbled upon the gun section, a display that was particularly mesmerizing for Hugo because he was an international student from France. They bought a BB gun for under $30. It looked just like this, and they returned to campus to gather a few more things. As they drove across campus to the barbecue, they tested out their new gun by shooting at trees. Several people saw them and made frightened calls to the campus safety department that someone was shooting a handgun. There was a flurry of activity on campus radios, and parts of the campus were put on lockdown. And at one point, a facilities worker got word of the incident and saw the two students driving down the road. The facilities worker jumped in his truck, chased them down. He caught up to them and escorted them to the campus safety office, where they were met by local police and arrested for reckless endangerment and weapons violations. The students immediately admitted responsibility, and this school, fortunately for them, had a restorative justice process in place. They had a restorative justice conference. It was led by two facilitators, and the dialogue included both Hugo and Dennis, the students who caused the harm, a faculty support person for those students, a campus safety representative, and the facilities worker who had chased them down. The facilitators first gave Hugo and Dennis a chance to explain what happened, what they were thinking at the time, and what they had thought about since the incident. They expressed their sincere remorse. They also expressed their fear regarding criminal charges and the possibility of suspension. And they also said they had a willingness to do whatever they could do to make things right. Hugo, in particular, also expressed confusion about guns in America. On the one hand, he had been told about gun rights and the Second Amendment, and he had been amazed at how easy it was for him to make a BB gun purchase, something he couldn't ordinarily do in his home country. On the other hand, he was shocked to be arrested for using what he thought was only a toy. Over the course of the conference, the facilitators then asked the harmed parties what happened from their perspective and to share their concerns over the incident. The campus safety representative talked about what it was like to receive the panicked calls across campus and how frustrated the students were and the faculty members and employees were to have their days interrupted by the lockdown. The facilities worker described himself as an avid hunter who immediately knew that the students were using a BB gun, and he wasn't personally afraid for himself. He was, in fact, chasing the students down to protect them. As they were heading off campus, he believed the local police, who had been alerted to the incident, and feared lethal confrontation. He was worried the police would shoot first and ask questions later. Hugo and Dennis were very surprised to learn about how their actions had caused panic and put their own lives at risk. They were also surprised that the facilities worker, who they thought was this dirty person who had turned them in and chased them down, really was out there to help them and avoid serious trouble. They expressed their embarrassment and their gratitude, and they apologized to the harmed parties and committed to doing additional apology letters to the first responders involved in their situation. Later, both of the harmed parties said they appreciated the opportunity to participate in the process, and that they weren't going to have a serious student conduct incident on their record. The students also talked about what it was like to be arrested and how they were treated at the police station. They felt humiliated and threatened as the police interrogated them and led them to believe they'd be facing serious criminal charges. When they were challenged to accept full responsibility, they felt supported as opposed in the student conduct process as opposed to the police process. Hugo in particular was concerned about deportation, and the school helped mediate that conflict and helped Hugo believe that he was going to still be a part of the community. In addition to all these steps that were taken to help Hugo and the students involved and the facilities workers feel better, Hugo also identified that there was a need to educate international students on gun culture in America. They agreed to research these issues and create an educational campaign for the campus community. And he also committed to making a presentation to the International Student Club. think this is a great story of how the restorative justice process can address the harms of everybody involved, the employees and the first responders, the students who caused the misconduct, and a rebuilding trust with the broader community and creating additional educational opportunities. Now, Hugo and Dennis's story highlights the multifaceted nature of understanding harm. Harm in our student misconduct matters involves a variety of challenges. We have emotional and spiritual harm, material harm in cases where there's damage to property or physical harm to the person. There's communal and relational harm. And as Hugo and Dennis's story highlights, there's inflamed structural and historical harms. And this is also highlighted by the recent events across this country. Let's break it down. In Hugo and Dennis's case, here are some of the harms that were implicated. There was an emotional harm of fear. The community was terrified that there was an active shooter on campus. There was a communal harm in that there were disoriented international students who didn't necessarily understand the United States' strange gun culture. And there was a structural harm, U.S. gun violence, which both contributes to the disorientation, but also contributed to the fear and the broader concerns across the community. Let's talk about the needs that we were able to satisfy there. We let the community know, and Hugo and Dennis let the community know, they understood why their actions, which were benign, had caused so much fear and harm. They acknowledged that disoriented students needed more education and training around some of these cultural issues. And there's a broader structural need for safety. And while that can't always be addressed, as educational institutions, we can facilitate dialogues around what that could look like. And in Dennis and Hugo's case, here were the outcomes. They apologized to individuals who were involved. They put together the educational workshop, and they engaged in a gun safety campaign across the school and helped organize it. These might seem like small acts, but on our campus communities, they can often have wildly successful consequences in strengthening our communities and responding to these sorts of misconduct. Let's flip it and talk about Anwen and Samir and our Title IX case. And in Anwen and Samir's case, Anwen was the harmed party and she was sexually assaulted. She felt, of course, disgust, emotional harm. She was physically harmed by the incident. She had an additional emotional harm, and that she felt disempowered and disenfranchised. And she was a victim of the sexual objectification, which is a structural harm connected with U.S. culture. What did she need in all of these things? She wanted Samir to acknowledge how she had hurt her. She wanted her to be engaged and to do better about helping the community understand what went wrong in their relationship. And she had a need to be reintegrated back into the community and validated. And she wanted Samir to play a huge part of that. What happened in their case? For their emotional needs, Anwen and Samir engaged in a series of letter writing exchanges, not dissimilar to what I described with Sam's case right from the beginning. And that's how they started their conversation that eventually led to a series of in-person meetings where they talked about the night of the assault and worked through what happened, where consent was lost, and how it could have been made better. For disempowerment, Anwen expressed she had a need for Samir to be more engaged, so they began doing a shared presentation where Samir publicly admitted that he had not understood the parameters of consent and worked through in the community how to better understand those social dynamics. And finally, to address some of the structural harms, Samir took it a step further, and he began doing presentations both in the local community with high school age children and in the fraternities and residence halls, and doing proactive presentations about bystander intervention, consent, effective consent, and other issues related to sexual misconduct to hopefully help disrupt the sexual objectification that's also often perpetuated by U.S. culture. They continue to do these presentations today. Now, while we've been talking a lot about how restorative justice can be used as a response to misconduct, it's also helpful to acknowledge some limitations. This is an article that came out in 2018 when the DeVos administration announced that the mediation would then become formally acknowledged that mediation would be an option for informal resolution under Title IX. And the writer said some really thoughtful things. I'm deeply worried that allowing mediation to resolve all forms of sexual violence at school's discretion will result in pressure for survivors to participate. Survivors should not be asked to compromise, should not be asked to self-reflect or reconcile relationships with someone that assaulted them. And that, most poignantly, mediation perpetuates the myth that sexual assault is simply a misunderstanding between two people, rather than what it really is, a violent abuse of power. And this is a total legitimate criticism of the use of mediation in Title IX matters. Historically, mediation was often used as a way of calling the student in and sending a student respondent to another university or asking them to quietly leave, as opposed to processing the complaint and meeting a survivor's needs. What we're proposing is something radically different, and let's talk about why that is. Mediation and restorative justice both share some commonalities. They both involve trained facilitators. They both often involve some form of shuttle negotiation, whether it's through letter writing or a facilitated dialogue, and they both often involve the use of the word mediation. Let's talk about why mediation is different and often insufficient in the case of a Title IX matter. In mediation is very often there is no guided or structured preparation. Everyone kind of goes in having a sense of what they want, and we're asked to compromise. There's kind of a sense of a shared responsibility that both parties are equally responsible for meeting a compromise. And the focus of a mediation is often on the facts and the evidence and how much evidence there is to support a claim and put pressure on someone to withdraw it. That's totally different than the restorative justice process that we're proposing. Restorative justice, as we laid out, involves substantial preparation of all the parties and dialogues to get people prepared in the appropriate mindset for restorative justice. It often involves the community and the institution's participation, as opposed to just pitting the parties against each other. It requires one party, the person who caused the harm, to accept responsibility. And it focuses on repairing the harms in the relationships and restoring trust. Restorative justice says it may be entirely one person's fault entirely, and that person may have to make amends. It may mean that there isn't a compromise. It may mean that the person doesn't accept the apology. It's a process by which people can understand these harms and try to make attempts to make a path forward. Finally, we'll say a quick word on restorative justice for reentry and reintegration. Just note that this is a increasingly important part of our student conduct programs is reintegration. This photo here is a picture of I won't say the school's name, but there was a school that had a graduate student who was involved in a sexual assault incident, and after a period of separation from the university, was able to come back to the school to finish his degree, and he had met the conditions for readmission. And upon showing back up at the school, was greeted by this crowd of protesters. And while we can all, setting aside the debate about reentry processes and policies, whether that sanction was appropriate, we can all admit that if we've decided that a student has we've meted out a sanction and the student has complied with it and taken steps to restore themselves, that as an institution, we have an obligation to support that student as they come back into the community. But that comes with both sides. We have to provide that support so they can reintegrate, but we also have to provide accountability so that our community can be reassured about their safety and their security. A final word on this, because it can be a whole presentation in itself, is that we're increasingly seeing reintegration circles and processes for employee and faculty misconduct, and particularly around professor misconduct that's not doesn't rise to the level of assault or severe harassment, but other sorts of power dynamics involved that create distrust and create challenges for students in educational programs. We're seeing restorative justice emerge as an option for mediating and mitigating those sorts of challenges. So I promised you we'd talk about some of the practical considerations and legal concerns. We've got a little bit of time left here, so we're going to dive into that for a little bit of time we have left together. What do you have to do if you want to adopt a restorative justice process in your student conduct policy? Well, there's 3 general phases. This isn't rocket science. You've got to prepare and adopt and do your research Someone has to make a decision that this institution is going to be committed to adopting those policies and practices. We got to look at our current policies and practices and determine what parts of our policies should be modified to incorporate a restorative process. We should develop a plan, including who are the key personnel who are going to be involved. What other support and resources do we need? What training do we need to get our personnel ready to adopt and to deliver this process? When we initially roll out a restorative justice process, again, it has to be accompanied with revised student conduct and other policies to make sure that there's clarity around what our obligations are and what our expectations are for students who want to participate in this process. Again, we're providing the appropriate training for folks involved. And we're implementing a protocol for screening and referring cases for restorative justice. We're looking at targeted locations, for example, residence halls. We're looking at certain populations, for example, athletics or particular fraternity or sorority, et cetera. And the reason we're bringing it down at the population level on this initial implementation is that we're looking for opportunities to gain insight and experience administering restorative justice before we start taking on some of the bigger, more systemic issues. So for example, you may not want your first restorative justice conference to be a major Title IX case. You may want to start with something else, some other sort of student misconduct matters, such as a residence hall infraction or other things of that nature, so that you can get your wheels under you, for lack of a better word. Finally, once you get some comfort administering your new restorative justice policy and practice, just look for opportunities to broaden and implement it on other levels on your campus. You can expand your program and your practices, and you're constantly assessing how you're doing to make sure that you're serving your community, delivering good responses, and that people are satisfied and understanding how this new process is bettering your community. Let's talk about the big, scary legal issues. And the good news is it's not as scary as folks would think. The reality is there's very few reported cases involving informal resolution and restorative justice practices. Of course, when we're dealing with non-Title IX cases, it really just comes down to breach of contract and negligence, and schools have wide latitude in administering their student codes of conduct. For Title IX cases, there's a few more legal considerations, and that's really what we're going to focus on in this portion. The federal court's been super resistant to allowing deliberate indifference to Title IX claims based on informal resolution. We'll talk about some of those key cases in just a moment. But in everything, the key issue is it has to be voluntary, and that's required both by best practice, it's required by the philosophical underpinnings of restorative justice, and of course now it's required by the Department of Education's Title IX regulations. But the bottom line is that the institution follows its policies and procedures. Again, that's why it's so important that we look at our policies and procedures before implementing restorative justice and formal resolution. The courts, at least of date, appear to be reluctant to second-guess these decisions or outcomes. Let's talk about some examples. Here's a great case out of the University of California. Sorry, I'm not picking on any particular school. It's just how the case law shakes out. This is a case called TACLA. And this is, of course, prior to the current department informal resolution parameters. In this case, TACLA reported a sexual misconduct, and the University of California system has a process called early resolution. And it's essentially an informal process that allows students to bypass the formal hearing process if there's a level of admission of responsibility. So traditional informal resolution. In TACLA's case, though, it didn't go so well. This is what the court observed. UCLA handled TACLA's report through what appeared to be a truncated process. Again, no good formal policy for how we're administering it, and no kind of monitoring of how effective it is. Most importantly, the way the university used their early resolution process in this case was in violation of their own policy, which prohibited the use of informal resolution in cases involving multiple complaints of sexual misconduct. And importantly here, the person accused in TACLA's case had several other complaints against him. Again, the key fact indicator of a quality restorative justice program is voluntariness, and is everyone coming to the table voluntarily in good faith? And in this case, the evidence showed that the UC administration discouraged the complainant from filing a request for a formal investigation. If we're getting requests for formal investigation and resolution, there are no questions asked. We are following up on that request. We're providing that student with their rights and options, and we're moving forward with our process. Again, here's another deviation from the school's policy. There wasn't any formal documentation of how the informal resolution process was administered. The complainant in this case was not told how the case was resolved, and left feeling not only frustrated, but again, in violation of the school's own policy. And finally, these last 2 points are important. The school took 9 months to investigate the report, even though it was doing an informal process. Even in an ordinary Title IX investigation, 9 months is an alarming length of time to investigate it. But again, using it, again, in this case, it violated the school's policy, and they didn't inform her of the outcome after this long process. So you can kind of see here, these are 5 kind of key missteps. And at the end of the day, it really highlights why we have to have a good policy in place, and why we have to train our personnel to follow that policy in order to avoid liability. Here's another case. This is the only case that I was able to find involving restorative justice informal resolution. Shank v. Carleton College. The case is about a year old now. And this is a restorative justice case where a conference was used for a reintegration matter. Again, this is a student who was found responsible for some sort of sexual misconduct, had served the sanction, and was coming back. And when the student came back after the suspension, the affected student, the complainant in that case, was still a student. So the college utilized the restorative justice process to bring that student back into the campus and reintegrate them. And it involved a series of meetings between and among the complainant, the respondent, and other impacted parties. The court observed that maybe there were some missteps in that restorative justice reintegration process, and acknowledged and ultimately found that conference did not violate the Department of Education's requirement that victims cannot be required to, quote, work out the problem directly with the alleged perpetrator. Remember, in this case, the student had already been found responsible, and this was a reintegration process. The court rejected the deliberate indifference claim, found that the plaintiff had voluntarily participated, and although she had soured on the process as she went through and was dissatisfied with the process, that every time she consented and voluntarily participated, and that the institution appropriately facilitated the conference by bringing in a trained facilitator. The court did note this important caution, however. It's possible to hypothesize a different case where a meeting is not voluntary, where a school knows or should have known that a victim's ability to make rational decision is compromised. Here, the school found that the student participated voluntarily, that there was no pressure to participate because the student had already been found responsible, and that the meetings themselves were not done with deliberate indifference. A word of caution, however, though, to the extent that you're hearing students complaining about the process, that's probably an opportunity and a moment to stop and evaluate whether it continues to be voluntary and whether we need to revert to a different, more formal process. Again, voluntariness is key. Here's another case out of California. This is Karasek. I won't bore you to tears with this. It's very similar to the TASLA case already discussed, but again, highlighting some of the missteps that can go wrong if you're using an informal resolution process. At no time during the pendency of the process was the complainant allowed to participate. During the entire pendency of the process, the respondent was allowed to remain on campus unrestricted, creating a hostile environment. The complainant was not contacted during the entire process. You can see how this sort of informal resolution differs dramatically from a restorative justice process, where the person, the harm party, the complainant, is central to the resolution of the complaint, is informed, and is not only informed, but is an active participant in the decision-making and the outcomes of the restorative process. The court in that case granted However, even considering all of those factors and the dissatisfaction of the complainant, most notably, the court granted the school's motion to dismiss and found that the student did not state a deliberate indifference claim. Even assuming that a school's violation of its own policy is relevant to the deliberate indifference analysis, the complainant identified no way in which the early resolution process violated the university's policy. Again, we're seeing a safe harbor of sorts start to emerge if you have a good policy and you're sticking to it. And we'll note that that policy was actually upheld, that decision was actually upheld very recently by the Ninth Circuit. And the Ninth Circuit admonished we might have handled the situation differently, but the Supreme Court has instructed us to refrain from second-guessing the disciplinary decisions of schools. Again, the decision to handle the complaint informally wasn't a violation of Title IX and did not exhibit deliberate indifference. So here, even in a case where things could have been much better and a restorative process likely would have ended in a much more satisfactory outcome, the court still refused to impute liability to the school. Two other quick cases here that don't warrant a whole lot of conversation, but I just wanted to flag them because they're out there. Here's this school, Hiram College. They have a lovely little mascot and flag that I found here for you. And again, this is a case, an older case out of Ohio, where a student brought a complaint of, like many students do, of sexual harassment prior to or right at the end of her time at the college. She was getting ready to graduate. Her and another student made the complaint, and the respondent in that case, upon receiving notice, acknowledged and accepted responsibility for the misconduct. They engaged in an informal resolution process, and the student went off to graduate school, and the other student remained at Hiram College. The plaintiff, Bertner in this case, was still unhappy with the assault and what happened. I shouldn't say assault, was unhappy with the misconduct and what happened, so she later brought this suit. The court held that she participated in the process voluntarily and did not show a violation of the policy or deliberate indifference. And our last case here, another case out of the SUNY State University of New York. Again, another school, another case brought where the student complainant was frustrated by the informal process, thought that it wasn't handled appropriately, and after engaging in some discovery, the Second Circuit in this case affirmed summary judgment in the school's favor, holding that the undisputed facts of this case, there was no reasonable jury could conclude that the response by the individual defendants on behalf of the SUNY defendants exhibited deliberate indifference. There's no evidence supporting Title IX liability. So the moral of these cases are: have a good policy, follow it, engage in constant assessment and evaluation to make sure that the parties are happy with our process, and if they're not, we're going back and reverting to our more formal process. Now let's have a word here. What we're not saying is restorative justice is for every single case. Informal resolution, including restorative justice, is just not for all cases. There are factors to consider. We're considering the nature of the offense. If this is a serious sexual assault or any sexual assault, I think it begs the question of whether or not it's appropriate for informal resolution. Now, there's a division in whether or not we should be using informal resolution for sexual assault cases at all. But for a story like Anwen and Samir's, which we kind of walked through earlier, is a great example of why we may need to rethink that consideration. The data supporting the fact that students aren't coming forward because they're worried about putting the people who harm them in some sort of serious disciplinary implication is even more support for maybe we should have a serious conversation about whether there are certain sorts of sexual misconduct cases that are blatantly not available for restorative justice, but maybe some that are. Certainly, if there's an ongoing threat of harm or safety to the campus community, such as a use of a weapon, or the next point, whether the respondent is a repeat offender, absolutely points that we should take into consideration, weigh against using an informal or restorative process. Whether along the way we assess whether the person is who committed the harm is participating in good faith or bad faith. If we don't have confidence in the person's participation, then it probably isn't a good fit. They're just trying to use the process to avoid some sort of more punitive or traditional punishment. Not a good candidate for restorative justice or informal resolution. Finally, we have to consider, again, the systemic big picture issues that affect student misconduct and whether the power dynamics of the case limit voluntary consent. And for example, the Title IX regulations blanketly prohibit using any form of informal resolution for student employee cases that meet the definition of sexual harassment. And that's good policy. We have to be really mindful of those power dynamics. And there might be others, a graduate student and a undergraduate student, certain sorts forms of domestic violence cases. We have to evaluate these cases very carefully and again, have trained folks who understand these dynamics, especially in the Title IX space, before we start referring these cases for informal resolution and restorative justice. And let's remember the bottom line. If you have a student who's requesting a traditional investigative adjudicative process, we give it to them. And if we have a student who's not willing to accept responsibility, who is in fact denying responsibility, we are absolutely using our traditional formal process. A quick word on ensuring voluntariness. This goes to the preparation process of the Restorative Justice Conference. We're building in our Tier 1 processes. We're educating and building consensus in our community about what restorative justice is and the role it plays in our community. But we're also providing really rigorous notice of people's rights and options in our processes. We're giving clarity on when you can use the process and when you can't. If you begin the process, when can it be terminated? Whether the information shared in those in our restorative processes can be used in subsequent conduct matters. And of course, the best practices know, and we'll talk about some ways just in a minute about how we can limit that. How restorative justice is different from our other process and whether or not we're going to require face-to-face interaction. Once we have that solid foundation and we understand and our students understand what they're getting themselves into, we ensure that no person goes to a restorative justice conference without participating in a preparatory meeting where, again, they're educated and they're prepared and they're asked to think about what they're going to bring to that conference. We're requiring our students as a best practice to sign some sort of agreement. We've drafted these model participation agreements that lay out exactly all the points that we've just talked about to make sure that people understand and acknowledge, and we have written record of of how we're handling this case. And we're engaging in frequent check-ins and monitoring. Again, as shown by the cases, we have to make sure that students are satisfied with our process. And if they're not, we're either modifying the process or reverting to our formal process to ensure compliance and ensure that students' needs are being met. Hinted at the compliance, we've talked a little bit about the new Title IX regulations. The final regulations are identical to the proposed regulations with respect to informal resolution and mediation. One thing worth noting is that the Department of Education has made clear that we're going to maintain stringent records requirements. You know, it has a longer period for how long we're keeping the records, and at every step of the process, once we have a formal complaint within the meaning of the Title IX regulations, that we're maintaining records. So we're documenting when we're offering informal resolution, including restorative justice. We're documenting any sort of formal agreement, putting it in the file. We're keeping notes about that process so that if we get a compliance review, we can demonstrate that how we handle each individual case. Again, our rights and options consistent with Title IX and the Clery Act and Campus Save and VAWA. We're memorializing those rights and options. We're publishing that information broadly, giving it to students when they come in with a complaint. We're ensuring that we have appropriate personnel and training. Remember the editorial about why mediation is not a good fit for sex misconduct cases, and so being mindful of that. We're having trauma-informed, appropriate personnel facilitate these events. And again, once we have a final informal resolution agreement or restorative justice agreement, we are monitoring compliance and whatever this misconduct it is, but particularly if we're using it in our Title IX cases, we are enforcing that agreement using our student code of conduct if it's violated. Now, one of the key things, this is going to be the last point, legal point that we'll talk about today. One of the main challenges that schools and many other institutions face in implementing a restorative justice program is that these sorts of admissions, particularly in those cases involving sexual misconduct or other misconduct that involves criminal activity, those respondents are often reluctant to participate because they are worried that if they admit responsibility, it's effectively admitting that they've committed a crime and that they could face some sort of criminal or other civil liability. And I don't have the most satisfactory answer for you, but I have some ideas about how we can mitigate that. First of all, in my home state of Texas, we're actually required now under a new law to ensure that every school has an MOU with folks in the community, including healthcare providers, victims advocacy services, and critically, local district attorney's office and law enforcement. And as part of that process, we're seeing increasingly schools negotiate with law enforcement to ensure that certain categories of cases that come within the agreement will be handled informally by the school before any sorts of criminal prosecution is undertaken, and that even if criminal prosecution is ultimately done, that the statements made in the school's restorative or informal process will be privileged and not available. And we've drafted a model MOU that will help schools have that sort of conversation. And while that's largely dependent on the politics and the personnel in your local DA's office, we're hopeful that that can be a good option. We can require as part of our process, and this is a best practice, that some sort of confidentiality agreement for both parties, that whatever we're saying in the course of our informal resolution and restorative justice processes are confidential. As a practical matter, we may not be taking as many notes or documenting statements that people are making in the informal process, instead allowing the organic flow of conversation and information drive the process. Again, that relatedly, looking at civil litigation waivers, mutual confidentiality agreements. A final consideration is that we may have some opportunities to have some level of privilege or confidentiality under state law, or even under the federal rule. I've quoted for you here, Federal Rule of Evidence 408. I've never seen it necessarily used in this context, but there's at least a credible argument that you can make that especially in the case of a Title IX sexual misconduct matter, that it is a statement made during a compromise negotiation. So maybe that could be some protection. But honestly, the best way to have this sort of protection for contemporaneous legal proceedings, besides having the MOU and some sort of agreement or confidentiality waiver or agreement, is having a state law. And I've given you a quote from Nebraska, and there's several other states, a good amount, that are now adopting these sorts of laws that actually specifically protect statements made in the course of a restorative justice program from disclosure to law enforcement and to civil cases. We're seeing these sorts of statutes pop up largely in the context of victim offender mediations and dialogues. Remember Howard Zare, who we started our presentation out today. We've seen them growing increasingly in the K through 12 space and for juvenile justice cases and diversion cases. And I'm hopeful that as restorative justice, understanding for restorative justice and alternative resolution grows in the higher ed space, that we'll see more laws protecting these sorts of statements to give students assurances about the statements they make in these processes, so that they can participate good faith, fully accept responsibility, and create the path forward. I'll leave you all today. There's a ton of resources out here. I know we've only been able to chat for about an hour and walk through some big picture. I could talk about this all day, but I'm sure that you guys have other things to do, other things to learn. But in the meantime, I really recommend that you get plugged into some of these really amazing resources. And first and foremost, I got to give a huge shout out to my good friends at the University of San Diego Center for Restorative Justice. They have an excellent facilitator training program where if you have student conduct professionals who are interested in learning how to facilitate these conversations and these restorative justice conferences, USD is the way to go. I participated in that training myself, and it was an amazing, transformative experience. And I came out of it having not only a deep understanding of restorative practices, but also really practical experience facilitating these dialogues. So shout out to them and recommend joining it. They also have these really excellent Google groups that you can join if you want to join the conversation and dip your toe into the dialogue that's happening around restorative justice. I recommend that you sign up for these Google groups. You can see that they're tailored around various constituencies, Catholic groups, bias incidents, medical professionals, K-12, and of course the Campus Prison Project, which is committed to restorative justice and Title IX matters. Recommend joining one or all of those, and that's a good way to continue to get almost daily updates about what's happening in the restorative justice space. Great book of a great series that I would love to recommend to you all is there's probably 20 or 30 of these little books of restorative justice, and they're tailored around various constituencies. And this book by my friend David Cart at the University of San Diego, RJ for colleges and universities, it's an excellent resource. It's only about 100 pages, and it's broken up in a way to both educate you about restorative justice and have a manual for how to facilitate these conferences, including a script for how you can, and the questions and the prep for how you can actually handle these matters on your own at your institution. I'll say two other quick words, which is, here are some other broad organizations, the National Association in Community and Restorative Justice. It's a national group committed to restorative justice across all industries, including education. NASPA is out there. I know many of you guys are members, doing excellent webinar series and trainings around restorative justice. And I'm really excited to announce that myself and my colleague Scott Schneider here in Austin have just agreed to work with the SUNY Student Conduct Institute. And we're going to be putting together a series of instructional webinars, taking a deeper dive into all the topics we've walked through today. The SUNY Student Conduct Institute is a great resource. You should join it anyways. And you can learn there a little bit more about restorative justice. And I look forward to continuing the dialogue in that space. Wow, I feel like I just dumped a ton of information on you guys. I know that was such a high level, and I'm certain there are questions and concerns, and I'm sure I messed something up along the way. Please feel free to contact me. Again, Paige Duggins-Clay at Husch Blackwell. I'd be happy to answer your questions, happy to refer you to resources. If your school is interested in revising your policies or exploring a process for how we can integrate restorative justice into your campus misconduct process, would love to be a part of that. And I look forward to seeing you guys out there implementing this really important, powerful, transformative process on your campuses and making our communities and the world a better place. Take care.